Tonight, the legal soap opera in Fulton County, Georgia is taking another turn. Fulton County DA Willis plans to appeal the decision to disqualify her from prosecuting Donald Trump in Georgia. The split appeals court decision ruled her relationship with former special prosecutor Nathan Wade tainted the case. The majority writing, quote, while we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence in the integrity of these proceedings. It all started in January when one of Trump's co-defendants filed a motion to get her disqualified over the alleged affair. A judge held hearings in February and March, and both Willis and Wade testified. The judge ruled Willis could stay on the case only if Wade resigned, even though there was a, quote, odor of mendacity to their testimony. Wade resigned. The day after that, Trump's legal team appealed, leading to today's decision disqualifying Willis. A spokesman for Trump saying the ruling, quote, puts an end to a politically motivated persecution of the next president of the United States. Now, if Willis's office can't prosecute the case, a state special counsel will appoint a new prosecutor. Joining me now, former chief judge of the Fulton County Juvenile Court, Judge Linda Hatchett. She's also a friend of Miss Willis. Good to see you this morning, evening, Your Honor. You believed that she should not have been disqualified. Explain why.
Absolutely not. And I think, Laura, that the dissenting opinion sums it up best. It goes through the litany of the findings of the Superior Court in this case, and then it goes on to say, but in spite of that, they went beyond. For the first time in the history of this state, an appellate court went beyond that and said, but yes, it doesn't appear to be one thing, but we think that it's a rare situation, as you just pointed out, where she should be disqualified. I don't think there's a good legal basis for this finding. I think that it is wise that this case is going to be appealed, and we'll see what happens.
It is being appealed, and this is not the end of the story. I've been a friend and mentor at different points of finding Willis's career. When you look at the trajectory of the success of that appeal, how do you think she might fare?
Well, I wasn't surprised by today's ruling, unfortunately. I was not surprised by it. The Supreme Court will hear it. I mean, that's the next date in the Georgia Supreme Court. But what I can tell you is that I have known Fonnie Willis since she was a young district attorney assigned to my courtroom. And she is now what she's always been, very prepared, very tenacious. And I am clear that this fight is not over and that this will go on for as long as necessary. And the appeals may continue. I don't know how it will fare, but if you read the law and you apply the law, it should not have been such that she should be disqualified. Not only is she disqualified, the whole office is disqualified. Now, the thing that the Court of Appeals did not do today, Laura, is that they did not throw out the case. So the case is still pending. But as you mentioned, if they don't prevail, then another district attorney could well be appointed to try this case, which may be doubtful. It really may be doubtful that that will happen. But I will tell you that she is standing strong. I've talked to her. She is determined to do what she was elected to do in this county, and she's not going to back away from that.
What about the nature of the appellate statement, and I'm paraphrasing here, about the inability to cure this matter, the inability to take away that appearance of an injustice or impropriety? Is there some weight that you would give to how this is viewed more broadly?
I think it was an overreach, frankly. I don't think that this is a proper cure. And I don't think that it's been tainted to the point that the court describes, such that this cannot be fairly prosecuted. And so I don't think that that's a problem. I don't think it's the problem that they have described in this appellate decision. And I think had they looked at what has historically happened, this has never happened in this state. In 43 years, as Judge Bland points out in the dissenting opinion, the court has never taken this approach.
Well,
Never.
forget 43, Judge. How about 47? That's when you'll be the incoming president, and there are legal issues, including challenge over presidential immunity. Would this be an exercise in futility? Will this case even survive?
It may not. It may not. But I also think that as a matter of principle, the appeal has to go forward. And I think that there needs to be a correction about what happened with this case. As Bland points out in this dissenting opinion, there is a difference between what happens with the trial court, as you well know from your years of having practiced law and being a prosecutor. There's a difference between what happens with the trial court and the discretion that the trial court has and what the appellate court's responsibility is in this case. And I don't think that they followed the guidelines appropriately in this case. And so as a matter of principle, I do believe that this case needs to be appealed and that this needs to be corrected.
Your Honor, thank you so much for joining me this evening.
Always.